What you are witnessing is an absolute unprecedented breakdown of courtroom decorum. No warnings, no delays, no final appeals. On the direct orders of Judge Marcus Caldwell, United States Marshals have just physically intervened in a federal courtroom, seizing documents, blocking exits, and effectively placing this high-stakes trial into a state of total paralysis. The defense team didn't just cross a line, they obliterated it. Following the explosive leak of the Witness 14 tapes, Judge Caldwell issued a scathing final ruling that sent shockwaves through the entire legal system. Immediate eviction, full-scale lockdown. This isn't just an interruption, this is judicial warfare, and the justice system just reached its breaking point. So, what triggered this extraordinary intervention? 47 minutes before the Marshals moved, a devastating leak surfaced online. Audio recordings from protected witness interviews that were never supposed to see the light of day. Recordings that directly implicated members of the defense team. This isn't just another procedural dispute. This is a federal judge declaring war on what he called a systematic assault on the integrity of these proceedings. And I have the timeline, the transcripts, and the footage right here. Let me show you exactly what they're trying to bury. But first, understand this. Judge Caldwell is a 23-year veteran of the federal bench. He's presided over organized crime trials and cartel kingpins. He doesn't flinch, but multiple sources confirm that when Judge Caldwell viewed the contents of those leaked recordings, his expression changed visibly. A court reporter described his jaw tightening, his hands gripping the bench. Then he issued the order that stopped everything. Now, what was in those recordings that broke a 23-year judicial veteran? Here's what the Witness 14 recordings actually contain. Witness 14, whose identity remains sealed under federal protection order, was a critical insider set to testify about financial fraud at the highest levels. According to court filings, this witness had direct knowledge of falsified documents, hidden accounts, and coordinated efforts to obstruct federal investigators. The recordings capture 3 separate phone calls between Witness 14 and individuals the prosecution claims are directly connected to the defense team. In the first call, 11 days before trial, a male voice says, "You don't have to remember everything. Confusion helps everyone here. Just be confused." The second call escalates. "If you mention the March transfers, this becomes a different conversation for everyone, including your family's situation." Legal analysts reviewing this transcript have called it textbook witness intimidation with barely concealed threats. But the third call, the one that apparently made Judge Caldwell's hands shake, occurred just 72 hours before these proceedings began. A female voice delivers the kill shot. "The testimony package has been prepared for you. Study the summary document. Do not deviate from the prepared responses. Any improvisation, and we cannot guarantee your protection agreement remains intact." They scripted the testimony. They threatened to revoke witness protection. According to sources, audio forensics have now matched voice print patterns from these calls to phones registered to 2 associate attorneys. Judge Caldwell's response was immediate. "This court will not be made complicit in the manufacturing of perjury. The recordings contain operational details, references to payments, future considerations, and what happens to witnesses who go off script." Former prosecutor Daniel Harrington stated, "I have never seen evidence this explicit. This isn't a gray area. This is black-letter criminality." The evidence package includes 14 separate audio files, text message logs, and financial records indicating payments routed through a shell company. And here's the kicker that everyone missed. The recordings weren't leaked by prosecutors. They were leaked by someone inside the defense team itself. An internal fracture. Someone on the defense side decided to burn the entire operation down. Analyst Cassandra Webb told MSNBC, "You're looking at someone who decided that professional loyalty was less important than avoiding prison." This wasn't a procedural error. This was organized criminal conduct by officers of the court. And now there's audio proof. Now you've seen the evidence, but understanding how we got here makes this even more explosive. This trial began 17 months ago. The defense team employed what critics called scorched earth tactics, challenging every piece of evidence, filing motion after motion. Warning signs emerged. Defense attorneys caught communicating with a juror's family. A prosecution witness abruptly changing testimony mid-cross-examination. The bombshell moment came when the Marshals moved. Lead attorney Harrison Mercer began to rise, but 4 Marshals stepped forward simultaneously. 2 moved directly toward the defense table. 1 blocked the main exit. 1 positioned himself beside the court reporter. The gallery erupted. Mercer's face went white. His associate counsel physically stepped backward, her chair screeching against the floor. Mercer finally found his voice. "Your Honor, you cannot." Judge Caldwell cut him off with 2 words, "I can." The silence that followed lasted 11 seconds. Court transcripts confirm 11 full seconds of complete silence in a federal courtroom. That's when everyone realized this wasn't judicial theatrics. This wasn't a warning shot. This was the end. Don't go anywhere. We're not even close to finished. What happened next inside that locked courtroom is even more explosive. Think back to the 1970 Chicago 7 trial when Judge Julius Hoffman ordered defendant Bobby Seale bound and gagged. Then there was the 2007 case of attorney Mark Dreyer. But Dreyer acted alone. What's alleged here involves an entire defense team. The closest historical parallel is the Watergate prosecutions. Attorneys connected to Nixon's campaign were themselves prosecuted. Professor Thornton told NPR, "What we're seeing today may actually exceed Watergate in its implications for legal ethics." The key distinction is technological. The age of he said, she said is ending. When you have audio, you have proof. And when the proof is this explicit, the system must respond with equivalent force. Judge Caldwell's response was exactly that. He sealed that room as a crime scene. He believed documents at the defense table may contain additional proof of criminal conduct. He treated the defense table the way a judge would treat a defendant who pulled a weapon, as an active threat to the proceedings. So what does this mean? The attorneys involved could face charges, including obstruction of justice. If convicted, potential sentences exceed 15 years. And then the defense made it worse. Harrison Mercer's attorney released a statement attacking Judge Caldwell. Legal observers called it catastrophic. Former prosecutor Harrington called it professional suicide. Attacking a federal judge hours after audio evidence emerged is not a legal strategy. By 6 p.m., 3 junior associates had resigned. Mercer himself remains under investigative detention within the courthouse. This is about whether the justice system can police itself. A federal judge looked at officers of the court who betrayed their oath and said, "No more." Not with a strongly worded letter, but with marshals, with handcuffs ready, with every exit sealed. Here's where things stand. The courtroom remains sealed. Witness 14 has been moved, and an emergency hearing is scheduled for tomorrow at 9 a.m. Tomorrow will determine if this is the defining prosecutorial moment of the decade. Subscribe now, because I'll be covering every development.